Welcome to meeting number 4 of the Interim Joint Committee on Judiciary. Glad to have everyone here. We've got a packed agenda, and I do want to jump in and get started. Before I call the roll and approve the minutes, I do want to take a moment here and ask you all to just stop and pause for a moment. You know, we all have different paths to this job that we hold, and we have different people to thank for how we got where we are. One of the people that I have to thank for the job that I hold is a man named Sheldon Baugh. And Sheldon Baugh is a state representative, former state representative for Logan County, a lifelong citizen of Logan County, born in Lewisburg, served in the Air Force, and is about the mildest-mannered man I've ever met. And I got to know him when I ran for this job 11 years ago. And I was intimidated about Logan County. You know, when you're running your home county, you know everybody and people know who you are, and it's not as intimidating, unless you're in Jefferson County. I don't know how you guys deal with that. No. We're good. Sweet, okay. But in Logan County, Todd County, I was out of my depth and didn't know anybody, and Sheldon took care of that. Introduced me to folks, spent time taking me around. He didn't know me from Adam until I showed up at a county party meeting one night, Chairman Petrie, and got to know that group of dedicated Republicans. And then because of his work and his time investing in me, and he certainly didn't owe me a darn thing, I did better in Logan County than I did in Christian County. The people of Logan County are the reason I have this job. And Sheldon Baugh passed away a couple of days ago. He was a good man, and I wanted to recognize his life and his service both to the people of Logan County, the people of Kentucky, and to all of us. He was here before we were here and did great work for the people of Todd and Logan County. And if it's all right, I'd like to observe a moment of silence for the late Representative Baugh. Thank you very much. I believe his services are happening this afternoon at 1 o'clock Central Time, and it pains me that as much as I appreciate and I'm thankful for this chairmanship, it pains me that I'm here and not able to be there with Miss Baugh and his family. But if you're the praying type, I'd ask you to pray for the Baugh family and the people of Logan County that are impacted by his loss. So with that, thank you all for that. Mr. Secretary, would you please call the roll?
Senator Berg. Senator Carroll. Senator Deneen. Senator Neal. Senator Schickel. Senator Stivers. Senator Storm. Here. Senator Turner. Here. Senator Wheeler. Here. Representative Banta.
Present.
Representative Blanton.
Here.
Representative Bratcher.
Here.
Representative Bray. Representative Burke.
Here.
Representative Decker.
Present.
Representative Dietz.
Here.
Representative Flannery. Here. Representative Herron.
Here.
Representative Kulkarni.
Present.
Representative Lewis.
Here.
Representative Maddox. Representative Mosier. Representative Nemus.
Here.
Representative Petrie.
Here.
Representative Rawlings.
Here.
Representative Sharp.
Present.
Representative Stevenson. Representative Wilson.
Here.
Co-Chair Westerfield.
Here.
Co-Chair Elliott.
Here.
Thank you. Seeing that we have a quorum, we're authorized to approve our minutes. I'll entertain a motion to do that at this time. Motion from Senator Wheeler, a second from Chairman Petrie or Senator Storm. Pick one. All those in favor of approving the minutes of our August 3rd meeting, please vote by saying aye. Aye. Those opposed? Minutes are approved. Also want to recognize Joe Ross, our county attorney, Commonwealth's attorney, county attorney in Logan County. And, yeah, Representative Decker.
I would like for you all to welcome today a young lady from Shelby County. She's a senior. She's shadowing me today, Haley McGill. If you all will welcome her to the committee. Thank you, Haley.
Thank you. Any other guests we need to recognize? Okay, give me just a second. All right. Just want to do some housekeeping there. Thank you for that patience. You know, the work of the Judiciary Committee sometimes gets tagged for being for focusing a lot of time on criminals and defendants and what can we do for the people that break the law. And I'm thankful that we spend some time on that. There's important policy work there. There's a lot of things that we can do to make sure that the people who have broken the law change their behavior and stop breaking the law. And that's certainly good for them. It's good for their families, good for the community, but it's good for the community because when that behavior is corrected, there are fewer victims that we need to worry about tomorrow and in the years ahead. And I want to make sure that we spend some time in this committee for victims. The victims that we have in our criminal justice system are just as important as the rest of the players in the criminal justice system, and their voice needs to be heard just like everyone else's. I'm honored to say that I've just in the last couple of months have entered an appearance as counsel of record for a couple of victims in cases in my neck of the woods as counsel permitted now by our Constitution. And I realize even more so, I used to be a prosecutor, as many of you know, and being in a different role in those cases, I realize even more so the value of making sure victims know what in the world's going on. And I think it's important that we know what in the world's going on with the victims that we have and the cases that come through our system. And so today we're going to spend time talking about crime victims in a handful of different ways. And at the top of the agenda, we're going to go mostly in order, if not completely in order today. I want to invite our friends with Zero V up to the table. And all of you in this group, Meg, Angela, and Christy Birch with the Ion Center for Violence Prevention. I don't know if you all wanted to come up together, and it appears that you do. I welcome you all to give us an update on domestic violence policy and the work that you do here in Kentucky. And before you start, let me just say thank you. You have the floor, ladies.
We're just waiting for the PowerPoint to come up here quickly.
All right. Let me borrow this real quick.
There we go.
All right.
There we go.
Good morning. I'm Angela. It's on. Can't. All right. Is that better? All right. Good morning. I'm Angela Yanelli. I am the CEO of Zero V. And we're going to go ahead and let each of us introduce ourselves before we go ahead and get started.
I'm Meg Savage. I'm Chief Legal Officer for Zero V.
Christy Birch, the CEO of the Ion Center for Violence Prevention.
So I want to thank you, Chairman Westerfield and Chairman Elliott, for letting us come before the members of this committee and tell you a little bit about who we are now and what we do and have been doing for a very long time. Most recently, we were the Kentucky Coalition Against Domestic Violence, but we are now Zero V, and our name says what our purpose is: zero violence. There's a domestic violence coalition in every state and U.S. territory, and Zero V is proud that for the past 40 years or so, we have been serving the people of this Commonwealth in that capacity. So what do? Well, we advocate for the policies and laws that protect the safety and well-being of survivors. We educate the field, community partners, and the public on understanding the what domestic violence is and also how to prevent it. We have 2 signature programs. One of them is our 30-hour training that we do for advocates across all of our programs. And the other is the Batterers Intervention Program, which we have renamed because we obviously love to rename everything. We've called that now our Education, Accountability, and Change Program. We empower. We have a rapid rehousing program that provides rental assistance and case management services and financial funding to help people move into self-sufficiency. We've even developed 84 units of tax credit housing and hope to add some more very shortly. And through our network of 15 regional domestic violence shelter programs, we provide emergency, shelter, and supportive services across all 120 counties. So why did we change our name? Well, we know that our programs are out there doing a lot of work, and they're evolving in all of the things that they're doing, modifying how they provide services. So our coalition needed to evolve as well. Our work is very intersectional. Survivors come to us with a whole host of violence in their lives, not just gender-based violence, but they come with poverty, homelessness, racism, and many other oppressions. So we are reimagining what our state and our world can look like by increasing our efforts on abolishing the social conditions and changing the systems that let domestic violence exist, while creating opportunities for Kentuckians to live and thrive in safety and peace. And we are calling for unity. To end domestic violence, we need to engage our community partners, our elected officials, and the public. And it's to say it is not okay that 45% of Kentucky women have experienced context sexual violence, physical violence, and or stalking in their lifetimes by an intimate partner. It takes all of us working collectively to change the culture to one that rejects violence as a normal way of life. We believe we can be a Kentucky united against violence. The backbone of Zero V's infrastructure is, of course, our member programs, and there is one designated program in each of the area development districts. They provide state-mandated services, and they do it 24 hours a day, every day of the year, including through COVID, never close their doors. And we put this slide in here to give you an idea of the impact that our programs have been having on the programs, on the survivors that have reached out to us for help. So if you look at just over the last year, we have an outcome performance that we've been measuring. And the first one says that 93% of survivors have reported knowing more ways to plan for their safety. And the other one is 95% have reported being more aware of community resources available to them. That's pretty impressive. But then we're going to look back over the last 5 years. We wanted to give you a sense of the volume of work that our programs do. So over the past 5 years, we have sheltered more than 10,000 women, nearly 300 men, and nearly 6,000 children. And then on a non-residential basis, we have provided services to more than 64,000 women, more than 5,300 men, and more than 3,000 children. Now, thanks to the additional $3.5 million of general fund, that was direct service general funding that we got from the General Assembly last year, we've been able to lessen the gap in living wages for our advocates, but we've also been able to increase services provided to children. That's very important because compared to last year, our program saw an 88.5% increase in the number of children that received crisis intervention and a 36% increase in the number of children that received advocacy services. But we continue to have unmet needs for shelter and also transitional housing beyond shelter. And of course, year after year, we continue to see intimate partner homicides. So how do we report intimate partner violence? Zero V collects a variety of data points from all of our 15-member programs, and we report it to the Cabinet for Health and Family Services every single year. So we know who we're serving, and we know what services they're getting within our network, but we also know that there are other survivors out there that have not reached out to us yet for help. Further, intimate partner violence is an underreported crime, and many acts of domestic violence are not criminal in the statute. For example, emotional abuse, financial abuse, and isolation. And many of these types of abuses are things that a victim cannot get a protective order for. For years, there's been no way to know for certain how many victims of intimate partner homicide there have been in Kentucky. KSP included domestic violence homicides in their annual report up until 2018, but there was a lag between the year of the reported offenses and when the publication was published. The Kentucky Violent Death Reporting System produced one infographic devoted to intimate partner violence in 2019, but that was based off data from 2010. And for decades, Zero V has been putting together a list of names, combing through news service clippings, talking to our member programs, and we call this list our Speak My Name. And it's used during Domestic Violence Awareness Months around the state. But it is imprecise and it is imperfect. But it was the very best that we could do to recognize by name those who paid the ultimate price of a partner's decision to exercise power and control over their lives. So this is why Zero V supported Senator Westerfield's vision for a comprehensive bill that would set the stage for finding answers to questions such as, why aren't survivors reporting domestic violence? What are our statewide systems missing? And how many lives have been lost due to domestic violence, including corollary victims? So we thank you, Senator Westerfield, and all the members of the General Assembly for their investment in this effort to support survivors through answering these very important questions. And it is exciting to know that we've started this journey with our inaugural Domestic Violence Data Report that just came out. It was compiled by the Criminal Justice Statistical Analysis Center from the Kentucky Justice and Public Safety Cabinet. So my colleague Meg is going to tell you a little bit about what this report can and cannot tell us.
Thank you, and good morning to all the committee members and our wonderful chairs. Thank you very much for having us. I want to first qualify this overview of our brand new report that CJSAC has produced by saying that we could use this entire committee hearing and more to go through the report. But instead, we are going to highlight just a few of the critical stats. It's premature to develop assumptions based on this data alone, but we will be continuing to meet with stakeholders to dig in and understand these numbers. This report will be a baseline against which we can compare future data and assess what additional data might be needed. So this inaugural report draws from three sources of data: the Kentucky State Police, the Administrative Office of the Courts, and Zero V. KSP data comes from two sources: the JC3 forms and KY Ops, and data from LINK, and it's reported by Area Development District. The JC3 form was created as a mechanism for law enforcement to document information about incidents of domestic violence, dating violence, child abuse, or abuse of vulnerable adults. Any JC3s that concern children or vulnerable adults are sent to DCBS for their review to decide if an investigation is necessary, to determine if protective services may be needed in a home. The officer filling out the JC3 form can also note the charges for any arrests they make. Some of the offenses documented are designated as domestic or dating violence related through a specific UOR code. Other offenses don't have a UOR code with a specific domestic or dating violence designation, such as stalking and strangulation. This creates some ambiguity in how many of these reported offenses are in fact domestic or dating violence related. The total number of JC3s filed in calendar year 2022 was approximately 38,700, with a total number of arrests related to those JC3s of around 8,800. We don't know the causation or context of this gap between filings and arrests, but we'll be digging deeper into this and working with KSP to try to find out what these numbers really mean. I'm not going to go over each of these numbers that you see on this slide, but I would like to point out the reason why you're seeing two figures for homicides. The first one, 27, includes all the homicides reported in association with the JC3s. And the second one, 21, were those homicides that had the specific domestic violence UOR code associated with them. It's not known whether those 6 other homicide victims might have been children, vulnerable adults, or indeed intimate partners. We don't know for sure without looking at each case file. So what do these baseline numbers tell us at this point about domestic violence? Setting aside the ambiguity due to the UOR codes, from ad to ad, low numbers of offenses may reflect a community that is doing a great job at prevention, or communities where domestic and dating violence is not being reported. It may reflect law enforcement that is spread too thin or in need of more training, or it may reflect cultural considerations about what types of behavior will be reported or will be charged. Also, this JC3 data is not going to reflect corollary victims, such as the 3 police officers who were shot and killed last year while attempting to serve an EPO, or the number of suicides that co-occur with IPV homicides. This report doesn't give us context or causation, and keep in mind this is only the first year of baseline data. KSP has also provided data on service of emergency protective orders by law enforcement agencies all across the state, and this is pulled from the Law Information Network of Kentucky system. Approximately 82% of the almost 20,000 ex parte orders that were received were successfully served. The second source of data for the report is AOC, which includes information about criminal cases and civil orders of protection. Based on this data, it appears that approximately 20% of petitions for protective orders are denied outright. However, the initial denial of petitions may not be as high as 20% because data entered into CourtNet could be interpreted by clerks in a number of ways. Some cases where an initial order was entered and then later dismissed may actually be entered into CourtNet as a denial. So that's yet another thing that we want to look at more closely with the people from AOC. The criminal case filing numbers you see here are from Circuit Court. There's a slightly higher number of homicides here than in the KSP data, as there is with other charges as well. There's not perfect alignment between these data sets, and we will be talking to KSP and AOC about the reasons for that. Keep in mind that neither of these data collection systems were specifically designed for academic research. They were designed so that law enforcement can do their job and the clerks can do their job. Also keep in mind that as with the KSP data, the AOC data is based on the use of certain UOR codes. And if that is off because these codes are not being appropriately or consistently used across the state, then we're going to miss some domestic or dating violence cases in these numbers. The last part of this report contains our own 0V data for services provided in fiscal year 2023. And this data has been reported to the state every year since we came into existence 40 years ago. As you can see, even though our programs serve thousands of survivors and their children, we still have unmet needs for shelter because our shelters are operating at capacity and stay full. So what does this report tell us about the current state of domestic violence in Kentucky? There's too much of it. It affects children. We'll need to see ongoing years of data to identify trends. We need support to do deeper dives into what these numbers mean and support the collection of supplementary data to provide context to this report. At the end of the day, we still only have information about those interacting with law enforcement, courts, and victim services. We need to somehow determine why domestic violence remains so underreported, why so many survivors never reach out, and how to make it safe for all survivors to seek help. I'll now turn this over to Christy to tell you what our domestic violence programs are seeing on the front line of victim services.
Thanks so much. Thank you so much. I'm thrilled to be here. Statistics are critical to us in understanding the scope of the issue and also informs what work we need to do. But sometimes when we hear stats, we can hear these numbers and feel a bit removed, thinking, I really don't know anybody that this is impacting. So I'm incredibly grateful to be here to take a few minutes to talk about the reality survivors are facing. Again, my name is Christy Birch. I'm the CEO of the ION Center for Violence Prevention. It used to be Women's Crisis Center. We too have been on an evolution, and everything we do at ION Center ends in ION. Prevention, intervention, collaboration, transformation. We're the dual designated domestic violence shelter and rape crisis center, serving 13 counties and 2 ad districts, Buffalo Trace and Northern Kentucky. Every single day, 15 shelter programs work tirelessly to ensure the safety of survivors. If you walk through our doors, you will find a place where people can feel safe and cared for, a place to heal from the impact of trauma and violence. I've been doing this work for over 26 years, and I have never seen the level of extreme violence that I'm seeing today. We're hearing violence on hotline calls. We're seeing women released from the hospital. A woman was released from the hospital, and she couldn't even walk to our shelter van. I see people with severe injuries, attacked with weapons, hammers, axes, people strangled, suffering from traumatic brain injuries. I see children who are afraid to speak and play because they aren't sure if they're safe. A recent client shared, without our support and genuine care, he might not be alive today. Not only are we seeing gratuitous violence, survivors are also staying longer in our shelters. ION Center's average stay has increased over the past 4 years, from 27 nights to 46 nights. In fact, we've had survivors stay with us for over a year. And this is because of affordable housing. A survivor shared her thoughts regarding the housing crisis. She had a housing voucher, but she couldn't get anyone to accept that voucher. She said, "I feel like I have a winning lottery ticket that no one will cash." Lack of housing, longer stays mean victims not in shelter cannot get shelter because beds are full. Many of our programs have increased capacity even during COVID. ION took a conference room and made it into 2 additional bedrooms and a bathroom, including 9 additional beds. Even with those additions, this unmet need for shelter is so great. Survivors of violence are up against formidable odds, including lack of affordable childcare and flexible childcare for our 2nd and 3rd shift workers, or they can't take overtime because they don't have childcare. Lack of transportation, which limits employment and housing options and decreases economic stability. In a rural county recently, we helped a mom and 3 kids get to safety. She didn't have a car, so she had to run to a public place. Our advocates drove there, got her in the van, while her perpetrator circled the building. They were able to hide this person and her kids and get them safely to shelter. If a survivor does have a car, unfortunately, a lot of times it's damaged. We had a survivor walk out after her shift at work and found her brake lines cut and sugar in her gas tank. And unfortunately, public transportation is often not the answer. In urban areas, we're seeing limited hours or limited routes. And in our rural communities, it is non-existent. There is no Uber to call. Our communities continue also to need more mental health and substance use disorder services. For survivors of violence, this translates into long wait lists or possibly no places to get treatment. The majority of our programs don't have the resources to be able to hire in-house therapists. And if they do, they have long wait lists. Survivors need employment that can meet the needs of their families. We have a resident with 3 part-time jobs because she can't get enough hours at one to keep up with the increased cost of childcare, food, housing, and reliable transportation. Shelter programs are a lifeline, working to meet complex needs of survivors 24/7. Programs have seen a 54% decrease in VOCA funding since 2020, which has truly been devastating to our programs, resulting in programmatic cuts, advocate layoffs, staff leaving for better, more secure jobs. And the staff we do have are overwhelmed. They're taking on more and more jobs to try to fill the gap. Listen, we sit in the hard every day, but truly, if you know me, you know we sit in the hope too. And that's where prevention comes in. I know no one in this room is okay with violence happening, with folks getting hurt. And I want to leave you with a little dose of hope. Zero V and shelter programs engage in prevention. They do this through increasing protective factors like the things I just talked about, the accessing resources. They engage in secondary prevention, services that stop emergency situations from continuing or escalating, and tertiary prevention, which is the ongoing work to help survivors address short-term and long-term consequences and the effects of trauma. It's critical that we work to keep violence from happening in the first place. I was so honored to speak at the Joint Health Services Committee and talk about prevention at Ion Center. We have the largest prevention team in the state. And we implement the research-proven strategy Green Dot. Green Dot teaches people how to be active bystanders by giving them skills, tools, knowledge, and confidence to be able to see and realize a high-risk situation and do something about it. Kentucky, expanding these efforts to include all shelter programs and continued support of all rape crisis centers will truly save lives in Kentucky and measurably reduce violence. Survivors need what all Kentuckians need: safety, housing, income, safe communities, access to health care, quality child care, and education. I am filled with hope because shelter programs know what to do and how to do it, and it's working. And I know that together, with your continued support, it is possible to help more survivors while simultaneously creating safer communities. Thank you so very much. Appreciation ends in ION. Yep, doesn't get old. Thank you for this time and for your vital support and your years of support for survivors in Kentucky. Thank you so much. I'm going to turn it back over for Angela for some final thoughts.
Thank you, Christy. So what do we need going forward? After extensive surveying of our data and talking to our member programs, we found 4 main categories of need that we needed some support for. And although we know this is not a budget hearing, this topic is really critical to us, and we need to take the opportunity to share what survivors need. And we look forward to working with all of you in the upcoming session as budget decisions are made in the next biennium. So we've got 4 needs here. The first one is, the first and foremost, is our living wages and competitive benefits. As I mentioned earlier, the $3.5 million that we received from the direct service general funding did a great amount of help, but it didn't close the gap completely. We still have some of the lowest paid advocates that are not even getting enough money to be able to afford to live in a 2-bedroom home or apartment. We have still not completely reached a point where our programs are able to recruit new staff and keep their current staff. So this is our first and foremost priority, followed by, obviously, as you've heard in our statistics, the need to support children. We have a need for services to support survivors experiencing mental health and substance use issues. And lastly, an increase in the ability to access our shelter, especially with transportation services. So how much do we need? You knew you were going to get out of here with how much money we need. We need $9.5 million in each fiscal year, and that is just $6 million more than what the General Assembly appropriated in 2022. And finally, we want to show you our map, and we invite you to talk to and visit your local domestic violence program that's in your district, especially during Domestic Violence Awareness Month, which starts October 1st. So that's the end, and if you have any questions, we are here to answer.
Thank you so much, ladies. I appreciate it. I do have a couple of questions, and then we'll take questions from the other members. You mentioned on a couple of different slides 1,258 unmet shelter requests. Are those folks not being housed, like not even in a hotel room somewhere, that you're maxed out on either budget or room?
For that, we have a measurement that we use for our federal funders to define what unmet needs are for shelter. And it is the number of requests for shelter due to program shelter, safe homes, or sponsored hotel rooms being at capacity. So once we have a hotel room that we may have a relationship with that the program is paying for, when that's exhausted, the next thing we'll do is we'll go to our local program, maybe in the next area development district, and say, do you have room? If that doesn't work,
So unmet means you've gone through all of those backup
we've gone through
options.
everything. It doesn't count the folks that we have to put into homeless shelters or into other places just temporarily.
Well, and folks with employment or their kids are in school, it's not very easy for them to then go to our Maysville shelter if they need to be in our Newport shelter, right? So we often exhaust the small pot of money that we have for hoteling and are working really hard to figure that out.
Also, again, on a slide, several slides back on the inaugural report, the time of service for the IPO, it mentioned there was a footnote there, a little asterisk that mentioned it doesn't include, or it doesn't, you're not unsure if it includes orders that were never served. Is that not a question that we can get an answer to, or something that we can ask AOC to make a change to, or something, so that we can identify that?
Yes, and I'll start out by saying that obviously this data belongs to AOC or
Right,
KSP, and Zero V's job will be submitting our recommendations to the General Assembly and to the governor come November 1st. But I think it's best for the agencies that provided the data to try to answer those types of questions.
It just so happens AOC's coming up here later.
And I did let both AOC and KSP and CJSAC know that we were going to be talking about this report, so in case they wanted to be present, if there were questions.
My last question, you also mentioned, and I'm going to ask for your specific recommendation on this, even though it's in partnership with AOC or the state police, but you gave the instance of some ancillary data that's not included in the report, instances where, and you mentioned law enforcement officers, there were 3 that were shot in serving a protective order. I forget the other example that you gave, but what's a proposed solution for capturing that data?
That's a great question. We are going to continue to work with CJSAC and the other entities throughout the coming year, trying to prepare for the second annual report and trying to determine if there are other ways to capture that data. Off the top of my head, I don't know that KSP has any way to flag a case like that, because it would not be given the DV designator for the UOR. And so it may just be something that we'll have to put our thinking caps on, and for them to figure out some way to flag cases like that, and train their officers to do that.
Thank you. Any other questions for members? Representative Decker.
Thank you all for being here today. Thank you, Mr. Chairman, for allowing me time. I operate a homeless shelter in Shelbyville, and we appreciate your all's help. You provide classes for our women on domestic abuse. You refer women to us. And I've got a question. I just appreciate everything you do.
Thank you.
Thank you all. But you used to send money when you referred people, and you don't do that anymore. Are you out of resources when you refer women to shelters to send the funding also?
I feel like when we've lost the big VOCA cuts, we've lost some of that capacity to pull those resources in. So it's very difficult for us to provide some of those additional supports.
That's what I've been told, so thank you. But I do appreciate your help in identifying women who, you just talked about when you're out of space, you refer to local shelters. Thank you for referring to us. We appreciate every woman we're able to serve. Thank you for your classes, and thank you for being here today.
Thank you so much.
Representative Kulkarni.
Thank you, Chair. Thank you all for presenting today. This is some very, very important information. I had a specific question. Initially, I think when you were talking about why do we change our name, and you have a slide about the strength of the regional domestic violence shelter programs, I believe one of you mentioned that there was an increase in interventions with children. I wonder if you could talk a little bit more about that in terms of a percent increase, and also if you're noticing specific areas where there are more interventions with children, or is it across the board?
I can give you the exact number here in just a second. I don't want to misquote. I believe it was 869 for the crisis intervention. Yes, I actually got that right. And 302 for the victim services. So that the percentage sounds very high, but those numbers are actually pretty high in a year. And the second part of your question is we really don't know why this is happening. Obviously, in our work, things ebb and flow for many different reasons. Disasters and COVID is one thing. The others, it could be the Super Bowl. It could be any kind of event, a media event. We'll get ebbs and flows in what happens in our programming. And we're always trying to find out why. So right now, Zero V has 3 research projects going on. 2 of them are working with COVID and healthcare and trying to find out about domestic violence services and how they relate. And I believe that this statistic about the children is going to be big enough for us to think about doing that in the next round of research that we're doing.
I also know that primary prevention in our high schools is also leading to folks seeking help. So they're identifying, even though we're talking about how to prevent something from happening in the first place, they are learning some things and learning skills and tools, and then going ahead and seeking additional support on their own, whether they're talking to their guidance counselor, and that guidance counselor gets them connected with our children's advocacy, with our children's advocates in shelter, and those kinds of things. So we're seeing that on the ground. I think a direct relationship to that primary prevention work as well.
And I'm sorry, I didn't mean to ask why, I meant where. So where in Kentucky are you seeing an increase in these interventions, or is that even...
Where, like in the state?
Like in the state, yeah.
I do not have that data in front of me, but I can provide that to you later.
Thank you. Mm-hmm.
Representative Burke.
Thank you so much, Chairman, and thank you all for this presentation. My entire career as a social worker and lawyer has focused around families experiencing violence. So this is truly close to my heart, and I'm grateful for your presentation today. I was looking at the Kentucky State Police data, and the stalking and sexual offenses numbers really jumped off the page to me because at the risk of using a little bit of rhetoric, I think I've talked to 18 stalking victims this year, and I'm sure I didn't talk to everyone in the state. So what do you think we can do to get better numbers? Should we make proposals to KSP about how they can track those numbers? Or do you think that perhaps stalking is an underreported crime and that we need to do more to make sure that they're aware of the number of victims of stalking in Kentucky? Thank you.
Okay, you want me? Okay.
So, casting my memory back to the days when I was an assistant Commonwealth attorney long ago, stalking cases are difficult to put together. They're difficult to bring to court, and they're difficult to get a conviction. And I think they take a long time. It takes time to build up those cases. So I do think that stalking is sort of seen as a problem child crime, as it were. And it takes sometimes a lot of persistence on the part of the victim, to really get it to the point where somebody will walk it into court or charge it as a crime. I think that, like, when you look at the numbers for strangulation on this report, they're pretty high, and that strangulation law is relatively new. And there was a lot of training given to police officers across the state. So they're very aware of that charge and when they should charge it. And I think they were very excited to have that, tool in their toolbox for situations. And so I think over the years, there's been efforts to raise awareness about stalking, and that it is an actual crime. And I think that just sometimes, it just doesn't go far enough. So I know there's a researcher at UK, TK Logan, who would definitely agree with me by saying that It is often sort of the forgotten crime of victims, but yet so many victims experience it, especially when they've left an abusive relationship. So, and I think with the sexual offenses that were related to the JC3 reports, again, I do think that there may be victims who don't recognize the sexual violence as being sexual violence. Maybe they're more accepting that that's just a normal part of a relationship. And if the police officers aren't asking the right questions and getting the answers, then yeah, I think that can be very underreported as well.
Sexual violence is one of the most underreported. And what we see in shelter, if somebody comes in and they're experiencing intimate partner violence, it will take them a very long time to disclose sexual violence. It is just a longer journey. And so I think that is I think that's a big reason, that underreporting and not having to feel safe enough to finally disclose this very intimate detail of their life.
Yes, absolutely. Thank you both for those thoughtful answers. May I ask one follow-up? Thank you. Thinking about the bravery it requires, not only to file for a protective order, but then to pursue criminal charges. Do you think that the typical response where we see perpetrators released on their own recognizance within 24 hours, which is what I encounter frequently, do you think that those kinds of responses from the justice system are a deterrent to survivors reporting those things? Do you think that we could do better in terms of how we process perpetrators of domestic violence through the court system?
You want me to? You want?
I'll take a whack at that one. So I think every survivor's journey is different. And some survivors do feel safe reaching out to the systems, the court system, law enforcement. They are happy with the response that they get, and feel that like that has increased their safety. And other survivors, in their view, they have a bad experience. They didn't get the reaction or the results that they would have liked or that would make them feel safe. And so I think it goes without saying we can always do a better job. And I would, think that looking at pretrial release of those individuals who've been charged with a domestic violence offense has been a part of the conversation when there have been bills to, initiate some sorts of pretrial release reform in Kentucky so that people aren't sitting in jail pretrial just simply because they can't afford to post a bond. So we always bring that voice of the survivors to the table, to make sure that that statute that we have that specifically directs courts to do what they can to make sure that that survivor of that crime is kept safe. If that individual is going to be released pretrial, that statute is, kept front and center when we're talking about this specific population of people who are charged with this type of crime.
Thank you all so much.
Representative Nemes.
Thank you, Mr. Chairman. Well, thank you all for what you do. These numbers are important for us to have. Your work is not only important in keeping the women safe who have been victims and the men, but most importantly, perhaps, the children and their long-term effects. So I want to thank you for that. It's my understanding that some of these perpetrators, a number of these perpetrators have done this numerous times and perhaps have numerous victims. So my question is, are we harsh enough on the perpetrator?
Well, Representative Nemes, I'm sure that you're aware that there's a statute that allows for domestic violence assault fourth to be charged as a felony when it's a third offense within 5 years, even if it's a different victim, but as long as it's a domestic violence assault. So we do have that. My casual looking at any sort of numbers in that regard is that that's a very underutilized charge. So that's one thing that prosecutors could look at, and the police, typically I think no one's going to be looking at someone's criminal record until it gets to the prosecutor's office. So I think that would, be one avenue to increase accountability for someone who keeps doing the same thing. I know that judges in protective order cases are allowed to look at the criminal record and the protective order history of an individual, and hopefully our judges are, availing themselves of that opportunity when they're making a decision on protective orders. And I do know that there have been propounded over the years laws to increase penalties for people who have repeated convictions for violation of a protective order. So that's always a misdemeanor in Kentucky, no matter how many times you're convicted of it. And so that's something, again, that, the legislature has looked at from time to time. Those, I think, Representative Heverin might have been the last person to file that sort of a bill. And we do need to have accountability for behavior. That's absolutely true. That's why Zero V runs what we now call our Education, Accountability, and Change program, which used to be our BIP program. At the same time, we also recognize that as the General Assembly has been trying to grapple with, there are disproportional, problems with our, incarceration and justice system, et cetera. So we need to find that balance to make sure that if, we are going to exact any sort of harsher penalty, that it's across the board for all abusers and isn't striking hardest at one particular population.
Thank you. It's good to hear that I think we need more enforcement. We certainly need more education, but for the repeat offender, the best education are metal bars. So thank you for your presentation.
And our last questioner is Representative Dietz, and I want to give a special thanks to her. I can't take credit for Senate Bill 271. Linda Blackford is the reason that bill was even introduced at all. It was her suggestion, coming from advocates, you all, and the folks that you work with every day, raising that issue, which prompted the bill. And then Representative Dietz worked with the Justice Cabinet and others to make some adjustments to it to make this first report and subsequent reports better. So, Representative.
Thank you, Mr. Chairman. Much like Representative Burke, I have spent my whole career representing families in family law. I have spent since 2019 working with a particular case in northern Kentucky, and my question is about education of our judges. Because when I was talking to Christy before this started, there's a lot that leads up to before the act of violence occurs. It's the control, it's the siloing of relationships, right. The control over the money. So there's a lot that leads up before the act of violence occurs. Right. Not in every situation, but in a lot. And I'm wondering, and in my 4 years, my client had resources. Mm-hmm. We had the resources to hire experts that could teach our judge what was occurring. So when we talk about coercive control and those things, right. He was able to understand it. What can we do to educate our family court judges on what leads up to it? That the end result is the violence, but right. There's things that are leading up to it that they will see in their courtroom, and until you can tie it all up together in a bow form and present it and say, here it is, they don't see it. So what are we doing to help our family court judges identify this on the front end?
I think this is a perfect way that we can utilize our local programs. They're in every single ad district. And so I know that we would love that partnership to be able to talk more and more to our judges, especially like presenting that power, this power and control wheel, like everything about it. Like you don't have to have violence, physical or sexual violence, for there to be intimate partner violence. In fact, when you lose control on one part, like if I'm losing control financially, then I'm going to actually then start really making sure kids don't, like the kids are very much controlled, or I'm going to start sabotaging things at work. Like when you look at the whole wheel, like all of these different spokes, it's mind-blowing what goes into it before violence even may happen. So I think it's critical. Like this is a great opportunity, and I know I can speak for all programs. We would welcome the opportunity to connect more with our family court judges. We have some great relationships with some, but again, any support around that, we'd love to be able to talk more about that.
Thank you. Ladies, thank you. I appreciate your time. I appreciate what you do and what your teams do around the state.
Thank you all.
All right. I want to welcome up John Hardesty, the Executive Director of the Office of Claims and Appeals, the Victims Comp Board, as it was called when I was still a prosecutor, and Raymond Shields, who's the Executive Staff Advisor. I thought it'd be helpful for us to hear about the. Guys, I call it the Victims Comp Board. It's just what it is in my brain. I'd be interested to know, and I think it would be good for us to hear how you all are reviewing claims, particularly since we just passed the statute that made some adjustments there to some of the claims that a loophole was allowing to not be addressed or met. How claims are made, approved, and how you all are funded, or whatever else you feel we need to know about the Office of Claims and Appeals. So, gentlemen, if you would introduce yourselves, you have the floor.
Thank you, Mr. Chairman. I did that last time I testified too, so eventually I'll learn. My name is John Hardesty. I'm the Director of the Office of Claims and Appeals in the Public Protection Cabinet.
And I'm Ray Shields. As you said, I'm the Executive Staff Advisor for the Office of Claims and Appeals. I serve many different roles with OCA. I serve as the board clerk for the Crime Victims Compensation Board. I serve as one of its claims investigators, and I also serve as the records custodian for OCA.
And before we get started, I just want to take an opportunity to thank you all for having us in here today to talk about the good work our program does for victims and just for generally highlighting victims as part of the criminal justice process. I think you mentioned earlier that oftentimes more focus is on the offenders, but I think it's wonderful that there's been a lot of focus today on the victims who are in need of different types of assistance across the board. And I think all the programs on the agenda today really work towards that goal. And I'm excited to highlight some of the good work that our program does. So as you mentioned, you're familiar with the board as the Victims Comp Board. The Crime Victims Compensation Board is, as any public board, empowered by statute to provide financial compensation to or on behalf of victims of violent crime or other qualifying individuals who can apply for compensation. The board, in addition to administering the Crime Victims Compensation Program, also administers the Sexual Assault Examination Program, which we will talk about in a little more detail here shortly. The board is administratively attached to the Office of Claims and Appeals, which the legislature previously renamed the Kentucky Claims Commission as. So formerly the board was under the Kentucky Claims Commission. Our agency also includes the Board of Claims and the Kentucky Board of Tax Appeals. So the board has the power and authority to hear and determine all matters relating to a claim by a crime victim or a person with authority to act on behalf of a victim for compensation. And we'll talk in a minute about some of the categories of expenses and compensation that the board can provide. Under the current iteration of the board, there are 3 members, 2 of which are required to be either a victim, a close family member of a victim, or a victim advocate. On our current board, we have 2 actual victims who are serving in those positions. The 3rd member is an attorney with at least 2 years of experience as an attorney, and so our 3rd member currently is a very seasoned attorney. In terms of eligibility for an award and the time frame in which a victim or a claimant must file, a victim, of course, is eligible to file a claim. A surviving parent, spouse, or child of a victim of criminally injurious conduct who died as a direct result of the crime is also eligible to file for certain types of expenses. Any other person dependent for his or her principal support upon a victim, so if someone's reliant on a victim for financial support, they are eligible to file for certain types of compensation under the program. And then lastly, any person who is legally responsible for the medical expenses or funeral expenses of a victim. In terms of the statute of limitations, a victim generally is required to file within 5 years of the occurrence of the crime, or if the victim died, within 5 years of the passing of the victim.
I'm sorry to interrupt, but I'm curious about that last one. I in fact, I didn't know the last two major bullet points there about a third party who's responsible for the medical or funeral expenses. The 5 years, though, what if the case is still pending? Does that have any impact, or does that toll that time period, or is that good cause and I've still got to ask for that?
So do you mean that if the criminal case is still
criminal
pending?
Case is still pending. I guess so there's not a conviction, so they can't ask for anything then?
So we're actually not required to have a conviction by statute in order to pay a claim. There just has to be sufficient evidence of criminally injurious conduct. That's defined under the statute, and oftentimes, we'll have a police report.
Right.
There will be indictments.
But if the case then is still pending, and it's not unusual for a case to be sitting on the docket, particularly now that we've gone through COVID and there are trials that are years waylaid. Does that toll the 5 year?
So it doesn't necessarily toll it. We do get that sometimes where a victim believed that they needed a conviction before they could file, and so they'll wait to file until there's a conviction or a plea. And yes, most of the time in those situations, the board will apply the good cause exception. I would say the board is very good about looking at the circumstances of a case and assessing when it. So the rest of that statute says if justice so requires to apply the good cause exception. I think in those situations, the board generally determines that justice would require them to toll the statute.
Thank you. Sorry to interrupt.
Thank you, Mr. Chair. So yeah, that statute, or the statute of limitations, is subject to the good cause exception, which we talked about a little bit. There are a number of different circumstances where that has come up since I've been here, one of which is if a victim doesn't know about the program, if they have been traumatized to the point where it's difficult for them to process the crime until a while down the road. The board will consider all of those in determining whether to apply the good cause exception. This is an overview of the types of expenses that victims can apply for to either have reimbursed or for certain losses to have compensated. As you'll see, there is an overall award cap of $30,000. That was increased by the legislature, and I appreciate your all's work on doing that on behalf of victims. A number of caps were increased, which I'll touch on in a minute, but that overall cap currently is at $30,000, and so that's all categories of expenses that a victim applies for. The total award for all of those cannot exceed $30,000 for any one claim. Victims are eligible to apply for reimbursement of medical and dental expenses. There's no individual cap for those expenses. Those are subject, however, to the overall $30,000 cap. And of course, that is only expenses they owe or have to pay out of pocket. If insurance has paid those, then they're not eligible for reimbursement. Mental health counseling is also an eligible expense. Again, there's no individual cap, but by statute there is a 2-year limitation from when the mental health counseling began. So if a victim begins that, they can have that for a period of 2 years, at which point the program can no longer pay it after the 2-year period. The program can pay funeral and burial expenses up to $7,500. That was also a category that was increased as part of Senate Bill 282 last session. That was previously $5,000, so that increase has been very beneficial to many family members of murder victims.
I'd say, well, I'm going to interrupt again and make a suggestion. It's not in the statute. You all should share data with CJSAC on DV-related and sexual assault-related cases where claims are made. I think that ought to be reflected in that annual report too. That's something I think you all should pass along.
We can certainly do that. And that is something that we have found, is that those are generally, in addition to being underreported, as the prior presenters mentioned, there oftentimes claims are underfiled based on the number of those types of crimes that occur. Victims can also apply for lost wages or loss of earnings. That cap was previously $150 per week as part of Senate Bill 282 last session. The legislature doubled that, which is wonderful, to $300 per week, which is somewhat more reflective of the current financial state that victims find themselves in. And then loss of financial support is the last category. Again, that was doubled from $150 to $300 per week in Senate Bill 282. And that's if an individual is reliant on a victim for financial support, whether it's a parent or, sometimes parents are relying on children for financial support, and that individual is injured or killed as a result of a crime. They can also oftentimes apply for that financial support up to $300 per week. There are situations from time to time where the board has to reduce or deny a claim. These are the primary reasons that occurs. So failure to perfect a claim or provide supporting documentation. Our investigators, Ray is over an investigative group. They do a great job of working with victims to get all of the documentation and evidence they need to pay a claim, to substantiate claimed expenses. But sometimes we're not able to get all of the information we need to fully perfect or prove a claim. In those circumstances, the board will have to deny a claim, or if there's some expenses they've been able to prove and some they haven't, the board will award those that we have proof of and deny those that we do not. Another reason for denial or reduction is contributory conduct. That's a situation where the victim, as a result of their own conduct, took action to bring on the criminally injurious conduct. You could think situations of self-defense, oftentimes mutual combat. If two people get in a fight, one is severely injured, but say they were the initial aggressor, the board will consider reduction or denial in those situations. There are other times that contributory conduct comes into play, but that's a couple of examples. The exception to that is if the conduct involved the claimant or the victim trying to prevent a crime or attempted crime from occurring. So obviously in those situations, the board will not consider contributory conduct. And then lastly, if there is a collateral source that is available to pay the expense, then the board will reduce the award by the amount of the collateral source that was available or that actually paid it. So that can be a life insurance policy, that can be a health insurance policy for medical and dental expenses, that can be PTO if you're applying for lost wages, and estates, things like that. So I'm not going to spend a lot of time on our crime victims claim process. I could present for probably over an hour on that alone because it is very detailed. But I just want to give credit to our investigators for doing a wonderful job, and our board members in moving these claims along. So when a claim is submitted by a victim or a claimant, we receive the claim form, any supporting documentation they submit, and then Ray will set it up in our system. He'll send out initial correspondence to a number of different parties. And then if they haven't provided certain documentation they need to, we'll send out a deficiency notice. That will then be assigned to an investigator who will begin the investigation. They will work closely with the victim to ensure we have all information and documentation we need to prove any expenses that they're claiming. We'll get an employment verification form if they're claiming lost wages. We'll get itemized billing statements or medical records if there are medical bills, contracts, funeral contracts, things like that, to make sure that we have all the proof that these expenses were actually incurred. Once the investigator completes their investigation, they will submit an investigation report to a single board member who will review the claim, they will review the supporting documentation, and then they will make a recommendation to the full board on what action should be taken on that claim. That is served on the claimant, who then has the opportunity to file exceptions. If you're familiar with KRS 13B, that's sort of in compliance with that they have the opportunity to object to anything they disagree with in the recommended order. That will then go to the full board to evaluate the claim, evaluate the recommendation of the single board member, and then make a final decision on the claim. Once that occurs, a check will be requested if the claim's awarded. That will be provided to the claimant. And if there's an offender identified who has actually been convicted of the crime or has been charged with the crime, we will begin the process of collecting the debt from them, because by statute, any offender whose crimes we pay out an award because of, they owe a debt to the state. And so we will begin the process of attempting to collect that debt from them. We wait until they are actually convicted to collect that debt, but we will notify them of the debt. And then once they're convicted, we will begin to first ask them to voluntarily pay. If they don't voluntarily pay, we will work with the Department of Revenue, or if they're incarcerated, the Department of Corrections, to attempt to obtain reimbursement to our program from the offender for those payments. So briefly about the sexual assault examination program. This was a program created to encourage victims of sexual assault to appear at hospitals, have a sexual assault examination performed. Those exams include basic medical treatment, so labs, collection of forensic evidence, any HIV prophylactic medication that's needed, other certain types of medications. That's provided to the victim who presents to the hospital or medical provider, but by law, the victim is not allowed to be billed for those expenses. So if the victim has insurance and is okay with the insurance being billed, the hospital will bill that to the insurance. If either they don't have insurance or they are not okay with the insurance being billed, that will be submitted directly to our program, who will pay the expenses based on caps set by our administrative regulations. This is a little bit of information on the caps for the sexual assault exam program. I will not go through these in detail, but as you can see, they include facility fees, labs for the exam, examiner fees, fees for medications prescribed during the exam, and they include a pretty detailed breakdown of certain types of exams and medications given as part of the HIV prophylaxis prescription course. So reasons for denial of sexual assault claims, these primarily relate to the fact that insurance paid over the regulated amount, in which case our program would not pay anything if insurance covered it, or the fact that the provider did not provide the bills or the forms properly completed in order for us to evaluate and adjudicate the claim. I did want to take an opportunity to highlight some of the recent improvements to the crime victims program and the sexual assault program. Our staff does a great job in making sure these programs run smoothly, and with the help of the legislature and other organizations, we try to work every day to improve our processes to serve victims to the best of our ability. So as mentioned in Senate Bill 282, this past session, the legislature increased the award caps for all categories of awards that are available, which has been very helpful to victims, has increased the amounts we've paid out. Immediately, that bill had an emergency provision in it, so it went into effect immediately upon passage. One process change the board has made is when evaluating claims where we don't have sufficient evidence to award the claim, if it appears that the claim would likely be awardable, but for the fact that the victim has not been able to provide the proper documentation, instead of denying claims for failure to perfect, which comes with a lifetime bar to refiling that claim, the board has begun to deny them for lack of proper documentation and has begun giving claimants leave to refile, with the understanding that oftentimes victims experience trauma from the victimization that can come at its own pace, that can be experienced by the victim, at different times. Some experience it immediately, others experience it a year or two down the road. And so sometimes we find that victims will file claims initially, but as they get into the process of trying to document and perfect the claim, they are having to reface what happened to them, and it re-traumatizes them, and they're just unable to do that at the time. And so that gives them the opportunity to refile the claim down the road if they get to a point where they do want to continue to pursue it, and they feel more comfortable doing that. The board has taken action to streamline claim processes in a number of different ways. 2 years ago, the legislature passed a bill requiring trauma-informed training for the crime victims' compensation board members and staff. And so for the past 2 years, we have provided that training to our staff, especially focusing on secondary trauma, which is an issue for our investigators who investigate these sometimes horrific crimes in the process of investigating these claims. And I do want to give credit, I don't know if Christy's still here, but the ION Center did our first trauma-informed training for our staff 2 years ago, and it was really, really successful. They did a wonderful job, and I know everyone thought that it was very helpful to better understanding what victims go through, and then to better allowing our staff to deal with anything that they experience in doing their jobs. We recently secured a federal grant through VOCA Assistance, which is it's the same pot of money. It's the VOCA pot of money, but it's the assistance side instead of the compensation side, to hire a victim advocate for the board. This will allow the board to better assist victims in filing claims. We anticipate this individual will advocate for these victims at the board. Our investigators sometimes take on that role, but that's difficult because as investigators, they also have to remain objective when presenting cases to the board and preparing investigation reports. Our other goal for this victim advocate is to build a referral network with other victim service organizations and agencies so that we can refer victims to proper agencies for services that they need that our agency cannot provide them. As you can see, the services we can provide are fairly limited, and we have a lot of great organizations across the state that can provide much broader services. And then lastly, the Cabinet for Health and Family Services this past year increased the Medicaid reimbursement rate for sexual assault exams performed by child advocacy centers. By statute, we are required to reimburse CACs at the Medicaid rate. And so that increase, I know, has helped CACs better perform these exams, better fund the performance of these exams. That was temporarily increased from $538 to $894. It's my understanding that when CHFS performs a study of the actual costs of these exams to CACs, they're going to increase it further to better reimburse those centers for the exams they perform. In terms of statistics for claims received, victims we've assisted, and amounts we've paid out, I've included some statistics for the past 2 fiscal years. So as you can see in FY22, we paid out approximately $579,000 in awards and helped 165 victims just for the crime victims program. That's not including the sexual assault exam program. In FY23, that number increased pretty substantially to $964,000, and we helped 246 victims through granting them awards. That increase is due to a number of different things, one being the increases in Senate Bill 282 of the caps, the other being a really beneficial training program that Ray has put together and been presenting to law enforcement agencies, prosecutorial agencies, victim service organizations to spread the word about our program, to help people understand our processes and what it takes for a victim to be eligible for an award. And I will say that over the last couple trainings, I think in one of the most recent ones, he had about 90 attendees. So those trainings have been very, very helpful. We have a statutory duty to spread awareness of the program, and we take that seriously because the more people that know about it, the more victims we can help. So for FY22, we received 313 crime victim claims. For FY23, there was an increase. We received 361 crime victim claims. I will say that claim number increase has been pretty consistent over the past several fiscal years. We have seen a continued trend of increased claim filings, and we anticipate that will likely continue based on the education and then, unfortunately, based on some increases in certain types of crime. We awarded 165 claims in FY22. Again, these are just crime victim claims. So we had an award percentage of 69%, denied 31%. In FY23, we awarded 749 claims for an award percentage of 78% and a denied percentage of 22%. So I think a lot of you are probably familiar with the crime victim claim backlog that developed years ago. That was something that the agency has worked on since 2016. A lot of that had to do with a lack of funding to pay claims. And so as of 2016, and again, that was long before my time, so a lot of this is statistics I have received, but there was approximately a 3 to 4 year average processing time. Again, that related to a lot of claims that had been investigated, had been initially reviewed, and would likely be awarded, but there was just no funding to award them. So instead of denying them, they were just held until hopefully there was funding to pay them. There were $2.2 million of awardable claims that could not be paid due to a lack of funding, and 350 to 400 stagnating claims. And that does not include the claims that were being actively investigated at that time. So there were actually more claims backed up than that figure. At the present time, over the past 3 calendar years, we've averaged a 128-day claim processing time, and that is despite an increase in claim filings compared to having the same number of staff to investigate and process those claims. We are paying claims at 100%, which has not always been the case based on the lack of funding. And then all open claims today that are open prior to 2022 are abeyance claims, meaning that all claims that predate 2022 are claims that are being held and not processed because of pending civil lawsuits that may award the victim through that avenue, or estates that are open that need to be distributed before we can determine if there's anything left to award. Things like that give a valid reason for holding the claim in abeyance. As I mentioned earlier, we do have a restitution program, and again, this is different from court-ordered restitution. We refer to it as restitution, but it's basically our attempts to collect the debts that offenders owe for the awards that we've paid out. We have one restitution and collections officer, and she has a monumental job, as you all can imagine, but she does a really good job and works very hard to make sure we bring in as much revenue through this process as we can. In FY22, we received $82,650 in restitution and donations. In FY23, we received $358,471. However, that's a bit of an outlier because we received a single $230,000 check ordered by the U.S. District Court for the Eastern District of Kentucky in a large narcotics prosecution. So that was very helpful to the agency. But the amount we actually collected that year through restitution and donations was probably closer to $130,000 or so. These are some statistics about the sexual assault exam program. As you will see, we received larger numbers of claims for that program. In FY22, we received 889 claims, and of the ones we decided, we had a 68% award rate and a 32% denial rate. In FY23, we received slightly more claims at 1,153. We awarded 66% and denied 34%.
I know you're near the end, but I need you to go ahead and wrap it up.
Yes, Mr. Chair, let me flip through to a couple important slides. So these are our budget numbers. These are simply amounts we paid out from different funding pools for the awards we paid out in those fiscal years. These are our sources of revenue. Those are agency revenue, so this is not including federal funds and general funds. We have the restitution fees, traffic school costs that we get, court costs, miscellaneous donations are primarily the restricted funds we receive. And then the one thing I did want to touch on is the impact of Senate Bill 282. So if you see here, the first two columns are the number of claims we received in those fiscal years and the total amounts paid out. The third column is the effect of Senate Bill 282, and that is assuming that any claim where we paid the maximum for burials at the previous cap of $5,000, we assumed it would be paid at $7,500, and then for the prior loss of earnings, we assumed it would be paid at $300, and for the overall cap, we assumed those would be paid at $30,000 if they had met the prior cap. So in those fiscal years, we would have paid out $762,000 in 22, which is approximately a $200,000 increase, and then we would have paid out $1.2 million in 23, which again is approximately a $200,000 increase. So that will have a larger fiscal impact on our agency, but as mentioned, that's very beneficial to victims to be able to be more fully reimbursed for those losses. We've also included our contact information if you all would like to get in touch with us. We're happy to work with your staff to provide any other statistics or information that you need. And we really appreciate the opportunity to speak to you all today.
I appreciate you coming and sharing this information with us. And, of course, members, you've got that presentation in your materials, and it's on the website. I have two quick questions. One, do you know what your on the slide 2 before this, do you know what your collection rate is for each of those amounts? You showed what I thought I saw 2 slides back was what you actually took in. I'm curious what you were owed versus what you took in.
You're saying for the rest, collecting from offenders?
Yes, sir.
I do not have those percentages right now, but I can certainly let you know that. I will say that one issue we run into is the term I use as a lawyer is their judgment proof. A lot of these offenders have no money
Sure.
to collect from them.
Apart from any rationale for why you didn't collect.
Yeah.
And that's certainly one of the reasons why. I'm curious what the rate of collection is. If that's something you report back to us, that'd be helpful.
I will take a look and we will try to compile that and provide it to you all.
Second thing, do you have any lawful process for enforcing a decision that you've made to collect or to gather reimbursement from either a defendant? If there's a judgment in or a conviction in a criminal case and, of course, a judgment follows, that can be enforced. But do you have any civil process for enforcement?
So we do have processes for both of those. So by statute, when we pay out an award as a result of an offender's crime, it creates a debt owed to the state. And so we follow the debt collection process that the Department of Revenue follows in terms of we notify revenue of a debt that we are owed for an offender that's not incarcerated. And we will, again, this is after attempting to have them pay voluntarily. And they will attempt to initiate collection proceedings on those individuals. If the individual is incarcerated, we will work with the Department of Corrections to give them notice of the debt, try to get them to pay voluntarily. If they don't, we will give them a notice of intercept. They have an opportunity to appeal that. The board then considers it, assuming that is denied, we will then move forward with intercepting certain state wages that they receive.
Thank you. Any other questions, quickly, briefly? Yes, Representative Herron.
Thank you, Chairman, and thank you all for your presentation. I'm curious, do you all know, as far as the type of victims that come to you all to receive services, is that broken down? The reason why I'm asking is I'm curious of how much of these funds or how many folks who have been impacted by gun violence are receiving your services, and if they aren't, is there something that we need to do to ensure, especially when you're talking about young people who have been impacted by gun violence and the long-term trauma? And so I'm just trying to figure out, is there something that we can do from our end to assist and provide services, additional services for our gun violence victims?
So I appreciate the question, Representative. We do track the types of crimes for which we pay out awards. I will say that homicides are the majority. Am I correct? The majority of what we pay out.
Thank you, Representative. Yes, approximately 60 to 65% of our current caseload involve homicide, and probably roughly another 30-35% involve assault. So obviously, those two categories of crimes encompass a large majority of the claims that we receive. But again, homicides do, unfortunately, inhabit a very large percentage of our current caseload.
And the large majority of those homicides relate to gun violence. So, on our end, we are attempting to spread awareness of our programs, especially in areas where gun violence is most prevalent. Things that the legislature can do, I would have to give some thought to that and get back to you. I know there are we've worked with one program in Lexington, I believe it's called One Lexington, that focuses on specifically gun violence prevention. We are trying to coordinate with them. So any ability that the legislature has to assist these organizations in collaborating with one another and working with one another, I think always helps move the ball forward in that regard. So that would be my suggestion at the moment.
Thank you, Chairman. I have one more question. As far as the overall budget, I know that I saw some numbers. How much money are you all getting specifically from us, the General Assembly?
I don't know that I have those statistics in front of me, but we can certainly provide that to you relatively quickly.
Thank you.
And do you mean in prior fiscal years?
Yes.
Okay.
Thank you.
Thank you.
Thank you, gentlemen. I appreciate it.
Thank you, Mr. Chairman. Thank you, members of the committee.
All right. The next up, we've got a fellow colleague of ours who I had the pleasure of meeting earlier this year, former state representative in the great state of Georgia, Scott Turner. He is attending by Zoom along with Natasha Bennett. Representative Turner mentioned to me the Coleman-Baker Act, which was enacted in Georgia earlier this year, and it's a bill that was inspired by or prompted by two unsolved cases, one in 1990 and one in 2001, murder cases there in Georgia. And I'm going to let Representative Turner talk about that once he is there. He is. Representative Turner, I've just introduced you, and I mentioned the Coleman-Baker Act, and I've mentioned Ms. Bennett. You have the floor, sir.
Sorry about that. I'm muted there. Thank you, Co-Chair Westerfield, Co-Chair Elliott, members of the committee. It is a pleasure to be able to address my home state where I was born. And it's an exciting moment for me to be able to return home, if you will, to talk about some of the work that we've done here in Georgia on behalf of families who have had loved ones murdered and their cases have never been solved. With me today is Natasha Bennett. She is the cousin of one of the victims that the Coleman-Baker Act is named after, and she'll tell that story in a moment. But I wanted to talk about the legislation that we were able to get passed here in Georgia this year on an amazingly bipartisan effort that was modeled after federal legislation that also passed with very strong bipartisan support. There was a Republican senator, Senator Cornyn from Texas, and Representative Swalwell from California, who teamed up to address this issue. And together they were able to pass H.R. 3359, which was the Families Victims' Rights Act. And this bill only applies to cases with federal jurisdiction. So it's really a very small number nationwide because there aren't a lot of cases that the Federal Bureau of Investigation, FBI, has jurisdiction over. But they wanted to address the issue of cases that just are lingering too long. And we know now that with the advancement of DNA evidence and advanced investigative procedures and technology, that more cases can be solved even if they're decades old. And it provides a ray of hope for these families who've been carrying that burden of a question mark for just way too long. And so the federal legislation really does one really big key thing. And it says after 2 years from the time that a murder happens or a homicide happens, the family would have the right to apply through writing an application to the FBI to have the case reviewed. And if any new evidence is found, or if something could benefit from a new technology or methodology, then the case would be reassigned to a fresh investigator and reinvestigated from the beginning. And this is really important because a fresh investigator doesn't have any of the biases baked in to the investigation. And that's the big push. And so we took that piece of legislation and we tried to address some very specific concerns that we had here in Georgia. One of the things I've been listening to in the other testimonies and things that you guys are working on is this idea of data collection. We know that the GBI here in Georgia has over 500 cold cases since 1970. We have no idea how many there are in our local law enforcement agencies. There has just been a lack of communication of these things. And after a while, people stop working on them. They stop tracking them. They stop making progress on them. And we were able to look at certain jurisdictions in the state and see that there are over 50 in the last 50 years that have been unsolved in just one or two jurisdictions by themselves. And so we have no real idea in Georgia just how big the problem is. We do know our clearance rates are better in some jurisdictions than others. And some of them, you have a sort of a 50-50 chance of getting away with murder. Clearance rates are close to 55, 56% in some jurisdictions in Georgia. And so this is a significant problem about the data collection side. And so we introduced HB 88, which was named after Rhonda Sue Coleman and Tara Louise Baker, two cold case murder victims, one from Jeff Davis County and the other in our Athens Clarke County, where the University of Georgia is. And it sought to solve three significant problems that we see here. And the first was we modeled the legislation at the federal level to allow families to apply. Now, here in Georgia, because law enforcement had some concerns about 2 years not being long enough, we extended it to 3 years. So 3 years from the day of the murder or homicide, as the case may be, the family would have the right to apply for case review. And again, if anything new is found, or if the evidence would benefit from the latest techniques, then that case gets assigned to a new investigator, and they go about doing the business of trying to solve the crime. There are two other problems that we dealt with in the bill: the data collection problem. We actually mandated that every law enforcement agency at the municipal and county level, so our sheriff's departments and our police departments, report annually to the University of Georgia's Carl Vinson Institute, and instructed the Carl Vinson Institute to create a database so that we may begin tracking the stats around cold case murders across every jurisdiction in Georgia. And the third was a very specific instance. We had certain coroners and medical examiners around the state who were refusing to issue death certificates. This may not be a problem in Kentucky, but they were refusing to issue death certificates because they were afraid that the information that they were putting on the death certificates may give away certain details that only the victim and the murderer would know, and it might jeopardize the investigation in a potential prosecution. So they didn't want to put the cause of death on a public document, and therefore they were refusing to issue. In some cases, in the Baker case, it was over a decade, and this led to all kinds of problems for their family. They were not able to appropriately close down her estate. Her identity was stolen on multiple occasions, and which just caused the family to have to relive the stress and endure the horror of losing Tara over and over again. So it dealt with that as well, which was a very Georgia-specific problem that we dealt with. So that bill passed unanimously out of both chambers, and it was signed into law by Governor Kemp earlier this year. It was not just the legislation that we were trying to make sure that we were addressing for the families, but also making sure that law enforcement had the resources that they needed now. In Georgia, we had a $6 billion surplus. And so the question became, how do we spend this money most wisely? And a large portion of that was returned to the taxpayers through rebates. But we were advocating for the creation of a cold case unit within the Georgia Bureau of Investigation. One of the key differences between federal legislation and a state piece of legislation really draws on this idea of jurisdictionality. In Georgia, where the murder occurs, that law enforcement agency has original jurisdiction, and they are not required by any law to turn over that jurisdiction to any other law enforcement agency unless they do it on a voluntary basis. This is one of the reasons why we don't know how many cases there are out there. Again, the GBI has been called in on 500 cases that they have not been able to solve yet, but the locals have no real incentive to call them in if they don't want to give up the case. And sometimes that causes a lot of friction, especially with families who are asking questions and want to see additional resources put on it. So what we hoped to do to address the jurisdictionality question was to provide resources at the Georgia Bureau of Investigation that would exceed any expectation of a local agency, so that they could turn it over to this division, this cold case unit within the GBI that would have the resources. And so we were able to advocate. I went to the GBI and asked them how, if we were going to do this right, what would it look like? And they asked for 19 employees, 10 agents, along with agent in charge and all the administrative support, all of the real estate, the training, the equipment that they would need, the specialty training. And they came up with a figure that for Georgia, it was $5.2 million to start. That was their first year cost, with a $3.5 million annual budget to continue. And with a $6 million surplus, we were able to advocate that these were dollars well spent in the effort. So I forgot to mention that this work that we are doing, as a former state representative in Georgia, I'm no longer in the House of Representatives, but I've maintained relationships. And today I'm the executive director of a small nonprofit called Eternal Vigilance Action. Our mission is to advocate for policies which maximize the American promise of liberty and justice for all. And that justice piece really is well served by this effort. And I would hope that the other states like Kentucky would consider this as something that would be a process that would deliver answers to families who've been waiting really just too long for answers, and deliver justice when hope seems to have been lost for far too long. With that, thank you for this opportunity to tell you our story, and I'll turn it over to Natasha.
Good afternoon. Can y'all hear me very well?
Yes, ma'am.
All right, thank you. Mr. Chairman and esteemed members of the General Assembly, I come before you today to share with you the story of my cousin, Rhonda Sue Coleman, for whom Georgia's Coleman-Baker Act is in part named. Rhonda was a beautiful, vivacious young woman who entered this world kicking and screaming like all babies do on January 18th of 1972 in the small town of Hazelhurst, Georgia. From the time she took her first breath, her indelible spirit propelled her to make a difference in the world around her. For 18 years, she exuded happiness and joy to those who were blessed to know her. Her smile could bring warmth on even the coldest of days. Her desire to help others was evident in her dream of becoming a pediatric nurse and caring for the most precious and vulnerable among us. As she walked out of her home for what would be the final time, her mind was focused on the future. She was 2 weeks away from her high school graduation, and she was ready to take on the world. Her last conversation with her parents was about her future plans to attend Georgia Southern University. Hers was a future filled with so much hope and promise that would never come into being. After spending the evening working on senior class activities, Rhonda said goodbye to her friends for what would be the last time and drove off into the night. Within 30 minutes of her departure, her car was found abandoned with the lights on and the engine still running, her footprints leading away from her vehicle. For 3 days, an entire community searched every corner of Jeff Davis County for Rhonda, clinging to the never-fading hope that she would be returned safely to her parents. But on a warm afternoon, as other families gathered around the table for Sunday dinner, her parents' world was shattered with 5 simple words. We found her. She's gone. On May 17th, 1990, Rhonda Sue Coleman took her final breath as she left this world. She left it kicking and screaming the same way she came into it, but at the hands of a killer whose identity has remained unknown for 33 years. Since that dark day in 1990, her parents have waited for answers that seem to never come. With each tick of the clock, they continue to cling to the hope of one day learning why their daughter had to die. For over 30 years, a crucial piece of evidence sat unprocessed in the evidence room of the Jeff Davis County Sheriff's Office. Its existence only became known to the family after I had a chance conversation with a retired Sheriff's Department investigator. And it wasn't until the family told the GBI about the evidence that it was sent for forensic processing. And it still sits at the FBI's crime lab 3 years later. This was an oversight that could have been discovered earlier if there had been a process in place to require regular reviews of cold case homicides. This was an oversight that may have caused her family to bear untold years of additional suffering in waiting for answers. Answers that may come with the processing of this evidence. Now, Rhonda's case, like so many others, remains unsolved to this day. As Mr. Turner told you, across Georgia, there's an untold number of families who continue to wait for answers and justice for their loved ones. Families have lacked avenues to request a review of their loved one's murder. But that has now changed with Georgia's passage of the Coleman-Baker Act. Families across our state now have hope that one day they will receive that phone call or visit from law enforcement that finally allows them to find out what happened and find peace. The first phone call of hope from Milton and Gail Coleman, Rhonda's parents, came in July of this year. The GBI's brand new cold case unit contacted them to say that Rhonda's case had been accepted for review and possible reinvestigation. The once dim candle of hope having been rekindled with a simple acknowledgement that her case matters. Sadly, Rhonda's story is not unique to her or just to Georgia. Unsolved homicides are a reality for thousands of families across this nation, including Kentucky. But I applaud each of you for taking the time to consider what you can do to offer these Kentucky families hope. The legislation that you could put forth would represent a crucial step forward in the fight to bring justice for the victims of unsolved homicides. And I thank you again for the opportunity to share Rhonda's story with you and to speak on behalf of so many voiceless families and the victims. And I thank each of you for your service to the great Commonwealth of Kentucky. Thank you.
Thank you so much. Thank you for sharing your family story and for coming and I know you put some work and some effort into getting this passed in Georgia, and I wanted to make sure when Representative Turner mentioned it to me, I wanted to make sure that the right legislators, and I've got the best in the building in this committee, that they had a chance to hear it. So thank you both. I appreciate it.
Thank you for this opportunity, and if we could work with you to pass legislation, we're more excited to have the opportunity.
Thank you so much. All right, members, I know we've got there weren't any questions there, so I'm moving on to the next item. The last item on the agenda, Vine. I want to welcome up Steve Gold, our county attorney in Henderson County, Jenny Oldham, county attorney in Hardin County, and if Joe is going to, Joe Ross, county attorney in Logan County. Have you all come on up. And I'm sorry to abbreviate your testimony, but we start losing more committee members at 1 o'clock. So there you go.
We'll be
the floor is yours.
We'll be very quick, Mr. Chairman. Thank you for the opportunity to be here. So to give an overview about Vine and an overview of what we're saying, there was a thing that worked for years. It was great for victims. It doesn't work anymore. That's bad. Vine stands for Victim Information and Notification Every Day. It originated in Kentucky in 1996 as a project of the Department of Corrections and APRIS. It's been an essential life-saving tool for victims of crime. As a result of the murder of Mary Byron, who was murdered in 1993 on her 21st birthday by her boyfriend that she believed was still in custody. And had Vine been available to give her notification that he was out, that would not have happened. Vine was built for email, text, and phone call notifications of inmate status, releases from custody or escape, emergency protective order statuses like when those EPOs are served and court dates, and court case status, important dates of hearings. At some point in September of 2021, the data sharing between the Kentucky Administrative Office of the Courts and Vine ended, and victims were no longer able to receive or sign up for court notice information. All state victims information websites, brochures, including those of AOC, DOC, the Kentucky Attorney General, prosecutors' offices, still indicated that court notification was part of the Vine functionality. I want to note that currently the inmate custody information and emergency protective order parts of Vine do still work. In early 2022, victims began notifying our office that Vine wouldn't allow them to sign up for court notifications anymore. Our victims advocate, Linda Schreiner, who's here with me today, contacted AOC staff, and even a lot of them were surprised that the court notification process was no longer working. At that point, I brought the issue to the attention of the former AOC director and Senator Westerfield, which has led us to being here today after a series of discussions. I want to talk about the importance of automated court notification. Throughout the majority of my years of prosecuting and all of ours, notifying victims of court dates was near instant. When a clerk changed a court date in the computer, it automatically sent out information to victims. That was very convenient, kept victims informed quickly and efficiently. Automated systems don't get sick, they don't go on vacation. Court dates often change with little notice. While our victims advocates and prosecutors are aware of many changes in court dates, there are very many that we do not know about. If an attorney is double booked, ill, running late, or something like that, it's not uncommon for them or their staffs to contact the judge or the judge's staff or a clerk, and the date gets changed. In those situations, we don't necessarily get any notice. They just don't end up on the docket that day and show up on another one. Not too long ago, this happened in our court in Henderson. Brittany, a domestic violence victim, had taken the day off work to appear at the scheduled court date for her abuser. Our victim's advocate had met with her and coordinated with court security to ensure her safety. When Brittany and our victim's advocate arrived in court, they found out that her abuser's attorney had a scheduling conflict and had gotten the case continued the day before, unbeknownst to our office. Brittany took a day off work, prepared for the stress of seeing her abuser and speaking in court, only to be told to come back and do it all again next week. Sadly, Brittany's experience is only one of several similar situations. Automated Vine court notification would have avoided this. So we've talked a little about Marcy's Law today. You all are aware of that. One of the rights that it provides is for timely notice of all judicial proceedings. While prosecutors and victims advocates do all that we can do to keep victims as informed as possible, it's increasingly impossible since automated court notification has gone away. Marcy's Law was a policy articulation by both the legislature and the voters that victims should be afforded at least as much respect in the criminal justice system as their offenders. In fact, Section 26A says that victims' rights are to be respected and protected by law in a manner no less vigorous than the protections afforded the accused. It's essential for our justice system to protect and give life to the constitutional rights of all parties, which includes the right to fairness and due consideration of a victim's safety, dignity, and privacy. But what happened to Brittany and others like her is not that. So automated victim notification of court dates is nothing new. It existed for years and should again. Other states are still making court notifications part of their Vine. Kentucky led the way decades ago with the creation of Vine. We shouldn't go backwards in the level with which we respect the rights and dignity of victims. We should continue to approve and innovate. It's 2023. Our victims can get automatic texts telling them that their Amazon package is 10 houses away. They should once again be able to get one when a court date changes. We've had discussions with AOC. It sounds like they've got some potential solutions to that. I know you're going to hear about that, and we're hopeful about those. Thank you for your time and attention to this matter.
We don't have a lot to add. I think Joe and I are here to answer questions, what it looks like on the ground, and I forgot to turn that on. So we're just here to answer questions. Just to let you know, though, there is not another database that exists that prosecutors have access to where we could do this function. And so we want to avoid that delay that Steve pointed out. We may not even know that something has been moved. There's lots of reasons a court case or a court date might move, and we don't want our victims to suffer that delay. So happy to answer any questions.
I appreciate that. I do want, Joe, you want to say anything? No. I do want to have Director Comstock come up on behalf of AOC. As she's making her way up, I want to thank you all for bringing the issue up and speaking on it today. And we're giving it short shrift, but it's something we absolutely ought to fix. And Steve, your remarks just then are right on the nose. Court systems are using text messages to inform defendants of pretrial hearings. There's no reason why we shouldn't be able to do that for crime victims. It'd be nice if the crime victim didn't also have to do it multiple times, once for the F case, once again for the CR case. Once again, it's requiring too much effort on the part of crime victims to get something that we're responsible for giving to them. Director Comstock, welcome right here. I think we could probably stretch another hour into this meeting just for you.
You know what? That is okay. For those who don't know, I used to actually work for LRC for over 12 years. So Senator Westerfield used to be my Judiciary chair. So thank you all for having us. I will keep this short. My name is Katie Comstock. I'm now the new director of DOC and not DOC. I am the new director of AOC.
You don't want
Let's
DOC.
make a change on the agenda here.
And the lights go out.
And the lights go out. This is perfect.
I promise this was not
my
intentional.
First time.
All right.
And Beth Lucas with the AOC in
Thank you.
ITS.
Go ahead.
First, I want to reassure you all that AOC believes in and supports victims and victim notification. As they alluded to, for over 14 years, we worked with DOC and their vendor to expand Vine to do court notifications. And agree, it worked. The problem we had was around 2021. We started hearing from the vendor that they were changing their platform. And the way they were doing it, instead of it being specific to a specific victim, and we would pull that information and we'd provide the automatic notifications for the court proceedings, instead what the vendor was asking for was saying their platform now needed a broader set of information. They essentially wanted more of a data dump. It wasn't specific to victims. For certain offenses, they wanted all of the court data, and it was a very broad net. So the information, as you all know, court records can be very sensitive and confidential in nature, and instead it threw out for this incredibly broad net that could be your sister, your neighbor, anyone that you can imagine, or anyone in this room that would have had those offenses.
Was there a concern that they were going to monetize that data?
Absolutely. Monetize and not protect it, to be quite frank, because that's a lot of really confidential and important data, as
Yes,
you all
ma'am.
have seen, because our AOC data has already been mentioned several times in this committee meeting. While we are hesitant to provide this for some of the reasons we just mentioned, we know the importance of victim notification, and we worked for months to make this happen. So what we ended up doing was having language specifically added to our MOU with the cabinet and with the vendor that to ensure that victims received the notifications they needed, but also ensure that the data was protected and it wasn't used for commercial purposes. So twofold, protect it and make sure that your all's information isn't being sold to the private vendors. One of the things we did to ensure that the data was protected was to include language that after performing a search, the vendor was to delete our court records data. And so in April 2021, with that language included in the MOU, we signed it. We are hopeful. We want to do exactly what the prosecutors do. Victims deserve notification. Unfortunately, within 4 months of signing the MOU, we learned from the vendor that they were willing or unable to delete our data after the searches. Instead of deleting the data, they were moving it to another database. As a result, we suspended the MOU. We didn't cancel it. We went to them and said, we still want to work with you all. We just want you to adhere to the terms of the MOU that we negotiated for months and that you all signed and committed to. As of today, that has still not happened. However, I don't want you to think that victims aren't notified at all. It's just not automatic. Prosecutors have access to AOC's CourtNet. It provides up-to-date access to upcoming court hearings 24 hours a day. And we've heard from some Commonwealth and county attorneys that, again, it's not automatic. That's the preferred approach, but they are getting timely, reliable information so they can notify victims of the upcoming hearings. Now, I'm going to turn it over to Beth, who will very quickly talk about possible alternatives.
So basically, there are three. One, we figure out how to use the existing agreement and meet the terms and conditions of that agreement. Two, we return to a prior model that we used using CourtNet as the source data and provide only the data for that specific victim and that specific case. Or three, with a new case management system, work with the prosecutors, who hopefully would have a repository where they could receive that data automatically, is a word I like to use, through an API, and then would receive that notification. So those are really the three options in front of us. We remain open to discussing any and all of those options, and we certainly appreciate the opportunity to be here today to discuss that as well.
I want to have this is something we need to dig more into and need to hear more from. Again, we're not giving it adequate time today, but I want to have an ongoing conversation between the courts, the prosecutors, both associations of prosecutors, and with Justice Cabinet to see what the best solution of those three is, and what the price tag is or ought to be for whichever one we're going to pursue, or we can fund, or maybe one leads us to another. But the crime victims ought to be able to benefit from the system that functions and functions well, and it shouldn't be a burden on them to get the information, again, as I said before, that we're obligated to give them. Representative Nemes.
Thank you. I'm glad that Director Comstock is here. We went to law school together. I have high hopes for the future for AOC. I would say that presentation today is not acceptable. You have an agreement. If only AOC could figure out a way to find a judge to get an injunction, I think it'd be pretty simple. It seems like you have an agreement you could deal with. You need to get to court. This is not acceptable. This information this should be fixed by Friday. That's tomorrow. Go into court today. Hold them accountable to the agreement that they've already signed, which you think is acceptable. AOC also monetizes this data, so I don't think you could sit there and act like it's not a question of money to you as well. I don't care about that. All I care about is the victims need to get the information. You got an agreement that you like. If they won't do their job, sue them, but get it done now.
You want to respond to that? You're welcome to, or you don't have to. I want to give you the opportunity to.
No, I mean, I appreciate what you're saying, Representative Nemes. Speaking to the monetization of the data, if I don't believe we do, but as you know, I've only been here for a couple of months, so I can't speak with a lot of information. I don't know if Beth wants to speak on that. I would say anything that, again, I don't believe we are, but I can't go into details.
You
right
have a whole
now.
department that does background checks. I'm not interested in that question. The question is, it needs to be resolved. You can go to Judge Shepard and Judge Wingate, and their courts are open nonstop. Electronically file on your wonderful system that you guys have created. But saying that you don't know what to do is not acceptable. You have an agreement. Enforce the agreement.
All right. Thank you all. Thank you, Steve, Jenny, Joe. I appreciate it. Please give Herb my thanks. I know he's in trial. He's going to be up here, and I appreciate that. With that, members, we're not going to take up the proposed regulation that's on your agenda on item number 7. Regrettably, the cabinet has not decided to make changes that are consistent with what we've asked for. And you all haven't had a chance to see what they've proposed, which is not quite, again, what we asked for. And since you all haven't had a chance, I didn't get it until yesterday myself. So rather than finding it deficient, I'll let you all see it, and we might change the statute when we get here in January. With that, I do, before everybody leaves, Representative Nemes wanted to have the floor to speak on something before we left the room.
Thank you, Mr. Chairman. I'll be quick. I just want to know that at this very hour, Jake Luxemburger's casket is being closed. His family is lowering his body into the ground forever. And these issues are very, very complex. He was killed by a man who's out on felony diversion. May have been appropriate. Don't know. We'll get into that. It's very, very difficult. I'm not lobbying any allegations at that. But I'm saying that I look at this beautiful little boy, and I want to remind ourselves that this is why we are here. When we talk about how we help criminals, that's important. But it's only important insofar as it helps that little boy and people like him. People who've committed violent crimes have forfeited their right to generosity. We only are generous to them, and we only care about them. I only care about helping them insofar as it reduces, as you said, Mr. Chairman, future victims. But I want to remind myself every day that we are here for Jake Luxemburger and people like him. He should not be buried today. And so just wanted to put his picture up there out of respect. Thank you.
Thank you, Representative. Members, our next meeting is Friday, October the 13th at 2 p.m. Odd time, 2 p.m. Friday the 13th. Seeing no further business come before the committee, we are adjourned.